the Honorable Attorney General and Commissioner for Justice, Lagos State, Solicitor General and Permanent Secretary, Lagos State, directors, distinguished seniors and colleagues. Good afternoon. I'm Olamide Ibrahim, and it's my privilege to welcome you all to this edition of the Lens series, which I believe is a special edition. Special for different reasons. Number one, for me, it is special because it's perhaps the easiest Lens series for me to introduce. I mean, easy because I don't have to rack my brain about the topic. It's a simple word, counterclaims. And then the facilitator for today needs no introduction. I don't need to start thinking for sweet words to describe him because he is an embodiment of sweetness to all of us. So I don't need to be thinking about how do I introduce him, but we all know him. So for purpose of protocol, Mr. Lawal Pedro, SAN, we all know is a former Solicitor General and Permanent Secretary, Lagos State. Majority of us have had cause to work with him. And he's one of those who built the pillar that the Ministry of Justice is standing on today. So we all can remember his exploits in civil litigation. And it's an awesome privilege to have him with us here today to look at the topic, counterclaims. Well, the effects of not filing counterclaims can be very devastating, can be really, really devastating. I recall a particular case that I was handling. I mean, I'm still handling the case. In that case, so the claimants alleged that we engaged in self-help while sending them away from a particular piece of land. It was actually a jetty in respect of which they have a certificate of occupancy. And then we were like, okay, fine. The people who they gave the jetty to operate, we said that, okay, that they engaged in some kind of activities that violated health and safety standards in what's it called, LASWA law and all sort of things like that. So while we were at the address stage, it was while I was preparing the address that it suddenly occurred to me that these people have come with a particular claim. Our defense, even though very laudable, may not address the issue that they have brought forward in their counterclaim, even though we've gone through trials. But thankfully, it was easy for me to now bring an amendment in order to be able to come up with a counterclaim, to be able to address the issues. So if I didn't see that, you can imagine how devastating that could be. So as simple as the topic may sound, it's actually very loaded and complex too. And in addition to what Mr. Pedro has prepared for us, there are issues that we would like him to look at. And then we know that there will also be questions at the end of the day if some of these issues are not addressed. Now, the first of the issues is that we know that counterclaim is said to be independent. We want to know what gives it its independence. We also want to know under what circumstances the independence can be lost. Then when the main suit is struck out, what happens to the counterclaim? Can counterclaim be used in originating summons? Must counterclaim relate to the sender? What is the relationship between counterclaim and set-off? These are some of the issues that we would like Mr. Pedro to address as he goes through his paper. So without much preambles, please let me welcome Mr. Pedro. Oga, you have the floor, sir.
Thank you very much. Thank you very much. Lamine, thank you for your kind words of me. Thank you very much. I say good afternoon to everyone. The Honorable Attorney General. I've seen the Solicitor General and PAMSEC, learning directors, my whole constituency. I say good afternoon to every one of you. Well, we know that counterclaim, like you said, is a claim on its own too. Claim in which can only be filed by a defendant in a suit for a relief or reliefs asserted against an opposing party. that is a claimant. And of course, that is after the claimant must have filed his own statement of claim and have his own reliefs stated out. In the circumstance, the counterclaimant, who was a defendant before, will now become a claimant, and the claimant in the original action will now become a defendant. So that, in essence, is what counterclaim really stands for. And that is for a defendant to a suit who feels, rightly or wrongly, that he has a claim against the claimant himself. And it can be used as a way of set-off. It can be used as a way of what we call a technical defense also. So that's why a counterclaim does not fly in the air. It is usually attached or accompanied with his own statement of defense. That's why when you are filing it, it says statement of defense and counterclaim. You cannot file a counterclaim without filing a statement of defense. So you should note that. But when we get to the issue of originating summons, I will discuss that better. So I would have loved to make it more of interactive, but let me just go ahead. And I will maybe when it comes to question time. So the question you will ask, why counterclaim? Why counterclaim? One of it is what Mr. Olamide Ibrahim have just stated. Because as a defendant, even if the claim of the claimant, supposing A and B are fighting over a parcel of land, A, the claimant, B, the defendant. And B, the defendant, put up a very good defense, and the claim of the claimant is dismissed. That does not confer rights on the defendant, Mr. B, that is the owner of the land. It does not. It is only the claim of the claimant that was dismissed. That was dismissed. So, though you won the case as a defendant by getting the case of the claimant dismissed, it does not inure any advantage to the defendant against any third party. It can only operate as estoppel against the same claimant or his previous agent or assigned. You cannot say because, yes, Mr. A sued me and he lost, so I'm the owner of the land. No, unless you yourself set up your own title to that land and the court adjudge it. So you can say you now, as a defendant, counterclaimant, I have a judgment in my favor against somebody that I'm the owner of the land. So that's one of the reasons why you should counterclaim if you want to get a relief from the court as a defendant. So it allows a defendant to maintain an action against the claimants separately. And you have asked, why is it independent? I'll come to that. And one of the reasons why you also need to counterclaim is that you avoid multiplicity of action. So you reduce the number of litigation between the same parties on the same subject, perhaps in different courts also. So it is also very convenient, and speed is also attached to it because it is always joined with the statement of defense. So the advantage of counterclaim is to avoid multiple action on the same subject between the same parties. Now, then you ask the question, how independent, how separate is a counterclaim? Well, to me, it's undisputed that a counterclaim is an independent action on his own. So if the claimant's case is dismissed, stayed, or discontinued, the counterclaim may nevertheless be proceeded with. That is the position of the law. And I have a matter in court presently, and one of the parties have an application for stay of proceedings, forgetting that I have a counterclaim. So I'm not opposing the stay of proceedings of the main claim. It don't concern me. You can stay that, but you can't stay my counterclaim. So you can carry yourself away. As a co-defendant, I want to go on with my case. And that's why you have to be very careful on that, that once a case of a claimant is dismissed, struck out, you can proceed with your counterclaim. I think if I recall, you can have the case of Azan against registered trustee of Baptist. It's a 1993 case that have on that. You can cite for that. And there are a lot of cases that support that. Now, the next question you asked, what is the nature of a counterclaim? You asked, the counterclaim itself, must it relate to the principal action or different? To me, a good counterclaim that may not have issues of objection must relate to the principal claim before the court or the subject matter before the courts. However, I have seen cases that have held that counterclaim is an independent action and it needs not be in any way connected with the claimant's claim, or it may be raised, or it need not be raised out of the same transaction. It is not even not need to be analogous to the plaintiff's claim. I think that's the authority in Effium against Iron Bar. That is reported 2001 Nigeria Weekly Law Reports, part 678, page 341. I think that's all. It's a Supreme Court decision to show that, look, you can bring a counterclaim since the defendant, or since the claimant is the person you have a claim against, and you're already a defendant in his own action. It does not matter whether the case is related. But to be on safe side, I believe it's a Supreme Court decision, and we are bound by it. But to be on safe side, and to avoid any technicality, I will advise that your counterclaim must relate to the substantive claim before the court or the subject matter. And if you want to still ensure that the case is tied together with the relief you intend or you want to seek against the claimant, then I will advise that you file your own action separate and ask that the two be consolidated, because the parties are the same for one reason or the other. The court can hear the matter together, so that there won't be any opportunity for you to have an objection raised against your counterclaim. But the law is there. If it is raised, and I believe being bounded by the Supreme Court decision that I've just referred to, you can maintain a counterclaim that is not related to the subject matter or the claim, the principal claim, provided the claimant in the original action is the one to be sued. Now, counterclaim, you see, apart from being dependent, being separate, is also used to say is a cross action. So it must have its own separate pleadings. At the end of the day, it must have its own separate judgments. At the end of the day, it must have its separate costs. So therefore, a counterclaimant must prove his counterclaim, like a claimant to prove his claim before the court to be entitled to judgment. What a defendant to a counterclaim, like a defendant to a counterclaim, now is the claimant in the original suit. We all the rules guiding pleadings will also apply to counterclaim. So once there's a counterclaim, the claimant, the original claimant, who is now a defendant to counterclaim, must file a defense to the counterclaim. May even file a counterclaim against a counterclaim. And of course, reply to the defense. All those rules that governs pleadings on the part of the claimant, they also apply to the counterclaimants. The only nag that is there, because I recall the example just given by Lamide now, the only caution is to ensure that in filing a counterclaim, you make sure you do not plead facts that arose subsequent to the issue in the writ of summons. That means if anything transpired after the claimant must have filed his action, and you now decide to use those facts for the basis of your counterclaim, that counterclaim will be incompetence. In other words, what I'm saying is that the fact to be used to ground a counterclaim must be fact that was in existence at the commencement of the action by the claimants. And that is supported by the Supreme Court decision of Lawal against Ike Okongu. Lawal against Ike Okongu. I think that's 2003, LPELR 1336 Supreme Court. And that was the case in which the defendant counterclaimant even seek to amend. I think this time around, there's a counterclaim already. Issues arose during the pendency of the suit, and he sought to amend the counterclaim to introduce those issues or facts that arose after the commencement of the action. And the Supreme Court knocked down the counterclaim as not proper and is incompetent. So that is the only caution you must take note of, that in preparing a counterclaim, you make sure that the facts to be pleaded are facts that arose or that have been in existence as at the commencement of the main action. Now, another issue is how is counterclaim initiated. Now, counterclaim, being a cross action, is very much like a statement of claim. And it is initiated by filing a statement of defense and counterclaim. And like I earlier said, that counterclaim also will be governed by the rules of a counterclaim. You will not need to file a new writ of summons. That's the only difference. Your counterclaim is a statement of claim, but the only thing in initiating a counterclaim, you need not file a writ of summons for that. And once the counterclaim is filed and served, the original claimant is expected to file his defense as a reply to the counterclaim. Where no defense is filed or omitted to be filed, because I recall I see had a matter recently in Ikorodu High Court before one of our judges. I filed a counterclaim, and there was no defense filed to the counterclaim. And I applied to the court after address everything that, well, facts not disputed is deemed admitted. And so judgment should be granted. And the learned trial judge did not agree with me, saying that since my main claim, since the main claim is dismissed, the counterclaim must automatically be dismissed when they raise different issues. So in essence, what I'm saying is that you must not gloss over or omit to file a defense to a counterclaim if one is raised, because failure to do that will be deemed that the facts there are deemed admitted, and the defendant counterclaimant can apply for summary judgment on his counterclaim, like a claimant will do in the absence of defense. Now, the next question is, which is very important, who can be parties to counterclaim? Who can be parties to counterclaim? Can a defendant counterclaim against a defendant alone? The answer is negative. A counterclaim must necessarily be against the claimant in the suit or proceedings. Must necessarily be against the claimant in the suit or proceedings. You cannot add a defendant, where a defendant is also culpable along with the claimant. A defendant will not be allowed to bring a counterclaim against a co-defendant alone. This is because if the claimant is not made a defendant, if the original claimant is not made a defendant to a counterclaim, then there's no cross-action, and the counterclaim will be incompetent. So you cannot counterclaim against your co-defendant. And I think the case of Aibe against Paul Osa, Nigeria Limited, Paul Osa, Nigeria Limited, 2006, LPLER 7573 justifies that you cannot counterclaim against a co-defendant without joining the original claimant in the suit. Now, let me go to the knotty issue of whether a counterclaim can be brought in an action commenced by originating summons. There seems to be a controversy and uncertainty whether a counterclaim can be filed or is proper in an action commenced by originating summons. And I say this may be as a result of lack of specific provisions in many of our rules of courts in Nigeria. Although from my days in the ministry, I've always maintained that a defendant to an action commenced by originating summons can file a counterclaim in the suit against the claimant, against the original claimant, to seek relief or remedy against him in respect of the same or related matter to avoid multiple action. I have employed in my support, I can't remember that case again, we did one, Justice Oshodi of the High Court Lagos refused a counterclaim against an originating summons. I think there was an appeal. I don't know what befell that appeal that I refused to accept. We met outside again, we discussed it. He said he disagreed, and I said I disagree too, that you can. So I have always supported my argument and my position with the provisions of Order 1, Rule 1, Sub-Rule 3 of the High Court Rules of Lagos State, and also Order 56, Rule 8 of the Federal High Court Rules. That of the Federal High Court Rule is very explicit. It says, where a matter arises in respect of which no provision or no adequate provisions are made in these rules, the court shall adopt such similar procedure in other rules as it will, in its view, do substantial justice between the parties concerned. So I have always now referred the court to Order 8, Rule 7 of the White Book. I hope most of us know which book is referred to as the White Book. I want to answer. The White Book is the Supreme Court rules of England. So it's called the White Book. So if you look at the White Book, and I have one old archaic one that I have refused to throw away. I have the recent one in my library downstairs, but the one of 1979, White Book, the white has turned brownish now, but it's very good. They have grown. I'm very sure they have even removed it in the White Book of 2020. But in that of, because it has now been accepted that is part of their procedure, that you can counterclaim in an action commenced by originating summons. And the White Book is very explicit. 28, Rule 7 of the Supreme Court rule referred to as the White Book, especially that of 1979. I think I left one in the library in the ministry, so you can check on it. It's there. So it makes provisions, procedure, how you can counterclaim in an originating summons procedure. And I am delighted hard course also to handle matters in Akure and in Ekiti too. The Ondo State High Court rules have just absorbed, copied the White Book in 1979 in their own rules. Now, at least I don't have to go abroad anymore to look for similar rules. If there is none in Lagos, none in Federal High Court, to borrow from the state court rules, civil procedure rules. And Ondo State incorporated that order in his own Order 38, Rule 8. And this is how it provides, say, a defendant to an action begun by originating summon who had entered an appearance to the summon and who alleges that he has any claim or is entitled to any relief or remedy. Also note that his lordship, Honorable Justice Kekere Ekun, JCA, as he then was, in the case of Friday versus Governor of Ondo State, held in the instant case, in my view, I do hold the counterclaim filed by the respondent to the originating summon was competent and the lower court had jurisdiction to entertain it. And that decision was in 2012, Law Pavilion, Electronic Law Reports, is Friday against Governor of Ondo State. 2012, LPELR 7886, Court of Appeal, per Kekere Ekun JCA as it then was. Just to, clear the ambiguity of controversy. And you cannot file a counterclaim on an originating summon procedure or process. It is acceptable. The rules allow for it. And if there is lacuna in any rule, just borrow from a fellow state in Nigeria without having to borrow from the White Book. White Book, and also because of those states copy the White Book, make same provision. And that is exactly what I did in the recent case of Hotelier Association against AG Lagos State. in which I was privileged to represent the Attorney General of the state in a case challenging the issue of VAT and our consumption tax. The hoteliers went to court by way of originating summons, stating that the VAT has covered the field of all consumption taxes in Nigeria. And I recall we've been trying to fight this cause for many years in the Supreme Court. We have about 2-3 matters there. We always either discontinue, withdrawn. Even though a particular one, we got judgment in one consolidated suit, that's AG Lagos against Federal Attorney General Minister for Justice on tourism. Now, like Ibrahim said at the beginning of this session, that you may have to file a counterclaim for you to get a relief. So in that case, by way of originating summons, I adopted the white book, and I filed an application for leave of court to file a counterclaim in the suit. But my learned brother said, Mr. Shukwashara said, he don't even bother to oppose, because it's a matter we have discussed. He didn't even oppose the counterclaim. So he entered and the matter proceeded to trial. And at the end of the day, it inured to our advantage in Lagos, because the originating summons of the hoteliers was dismissed. So if you have not had a counterclaim, we will not have got another in our favor, stating that the hotel consumption law of Lagos State is constitutional, is valid. And of course, there's an appeal on that now, and I believe is an appeal we should win successfully. There shouldn't be any problem. But I must hint, because I followed that, and I believe the state will have been aware now. Is the DCL around? Anyway, people in DCL should look out. You know, they went behind Lagos State to file a fresh suit to challenge the power of the minister to increase to amend the schedule. So that's our decree, how do you refer to it? Collection of taxes and levies decree. So challenge it indirectly, trying to undo the judgment we got from the earlier case. And I think we should take note of that case. If you are aware of the judgment, and I think it was delivered by Justice Faji of the Federal High Court, steps should be taken to appeal it as an interested party or do something so that it will not take away the victory in the case we had by our counterclaim in the originating summon filed by the hotelier.
Hello, sir.
So to me,
I wanted to give you an information, sir.
Yes, go on.
Yes, we are aware of that matter, and indeed we have
found, that's good.
Yeah, so we applied to the court to be joined as an interested party, and our application was successful. So we have also successfully appealed to the Court of Appeal.
How did you do that? To apply to be joined?
Yes.
So is it before the judgment was delivered?
After the judgment was delivered, we brought in an application to be joined as an interested party.
Yes.
And of course, it was opposed by the ALP law firm. Eventually, Justice Faji agreed with us and granted our release. So we are at the Court of Appeal at the moment.
Was the judgment set aside by Justice Faji?
No, sir.
Is it not? Was it not Santos official?
So we are appealing that judgment.
Is that what?
We are appealing that judgment.
Hey, that's what. Is that? No, wait. You know, we are in the house now.
Yes.
In appealing that judgment,
go
and appeal that judgment as an interested party in the Court of Appeal. Now, what you have, once the judge in the Federal High Court delivers his judgment, it becomes something, it's a trap. It becomes, go and look at it very well, it becomes Santos official. He cannot join a party to a suit that judgment has been delivered unless you want him to set aside that judgment so that you can be heard. And that also may have problem. So your best shot will have been appeal to the Court of Appeal as an interested party, and that if you have applied in the Federal High Court to be joined, the Federal High Court will have joined us. So they will take that appeal. But if you file an application before 5DJ,
yes, sir,
to be joined
as
to
an
a case
party,
that you have delivered judgment,
yes,
well, maybe the procedure in the Federal High Court allows it.
yes.
So
and
I will look into it.
Another thing that I'm looking at is that because they joined issues with us, it was a very highly contested application at the lower court. So can they now go to the to the Court of Appeal to say that it wasn't properly done? Because I mean, if they did not say anything at the Federal High Court, then it could be proper for them to go to the Court of Appeal to say that we were not properly joined. But they responded.
Okay.
We were led to the matter.
Okay, let me advertise. Okay, let me advertise. Go and read my book.
Okay.
Can parties confide on court? No matter how well conducted, the judge is functus officio. So he lacks division whether you people consented, argued. Although I don't have the file and I don't claim to have monopoly, but if I have opportunity, if I look at the rules of the Federal High Court again, I'll get back to you. But general principle, the court has delivered its judgment. It is functus officio. The only order it can grant you people is stay of execution. That you have appeal, we have a motion to appeal with leave to appeal. So we have come back to you, stay execution. That's the only order, that's the only jurisdiction he has to grant. But to say he's joining somebody, another party to a case, judgment has been delivered. Unless there's an application to say, join me, set aside the order, let the matter be heard on the merit, this is my defense. Then the court can say, okay, I agree. You ought to have served them. That judgment I delivered, I set it aside.
Oh, sir,
number B.
Maybe there was maybe there was a kind of misinformation there. What we took before the court was an application for us to appeal as an interested party, not to join us.
Okay.
To join us. To now appeal as an interested party.
But you'll be on good ground if you apply to the trial judge for leave.
Yes.
To appeal
as an
against his judgment.
Yes.
But if I were you, I would not even bother, because that's a final judgment. And your appeal is as of right. You don't need leave, either of the lower court or the Court of Appeal. The only leave you need in the Court of Appeal is to appeal as an interested party, because it's a final judgment. You understand what I'm saying?
So anybody can come up at the Court of Appeal to appeal as an interested party, not being a party at the lower court.
Yes. All you need is leave of the Court of Appeal.
Okay.
To appeal as an interested party. There is no provision for it in the High Court. If you appeal within time and you think it's not a final judgment or it's not a judgment on point of law alone, then you can quickly come to the High Court for leave to appeal. You understand what I'm saying?
Yes,
and
sir.
That's, if it is a interlocutory judgment, you have 14 days. And if that application is not taken within 14 days, it lapses. So you carry yourself to the Court of Appeal. But if it's a final judgment, which I believe this is, even though it may be commenced by originating someone, it's a final judgment. There's nothing pending in the Federal High Court anymore. So your right is to go to the Court of Appeal as an interested party to appeal against it. So, but if you have applied for leave to appeal, it's surplusage. So you may not have problem.
Okay.
If what you applied for in the Federal High Court is leave to appeal to the Court of Appeal, and that's granted, and you now file your application, you now file your, have you filed your notice of appeal now?
Yes, sir. In fact, we've compiled. We have compiled. So we have done everything.
That is good. Then you are in good.
Yeah.
You are good there.
Okay.
The only thing they will say, you don't need that leave. That's surplus. So you understand what I'm saying?
Yes, sir.
So you should look at it very well. Now, the technical thing they may take there, look, they will say, okay, that leave ought not to have been granted by the Federal High Court. Yes, that you should have sought for that leave in the Court of Appeal. So even though you might have, let me see, you might have compiled record. Can you now seek leave now? I think maybe find time. Maybe when I come around, let's see. Let me see. Then what I can do.
Okay, sir.
Okay, then that's all right. It's technical. Okay.
All right.
Okay. I can entertain question now.
Oh, I hope I did not cut short the presentation because I know that you were still flowing. I know you were still flowing before that came. I want our people to get as much as they can. This is a rare opportunity.
So you didn't cut it short. Yeah, yes, that's all right.
All right, sir. Thank you, sir.
So I can entertain question.
Okay.
To flow better.
Yes, sir. Thank you, sir. Now, Rafi Tolani wants to know if you have a prepared paper for this discourse, because he says that it's important to have it.
Not really, but I have a synopsis. I have a synopsis that can be sent to you today.
Very well, sir.
Just 1, 2, 3 pages synopsis.
Very well.
So I'll send it to Yabo.
Okay, sir. Thank you, sir. All right. So it's time for questions.
You're welcome. Yes.
Wow. Thank you very much, sir. I mean, while the lecture was going on, Mrs. Odusoya wrote something in the chat box. She said, Uncle Pe did the law. For me, I can't find any better word to gone are the days of Timi the law.
I'm only trying.
Thank you very much, sir. Please, let's have questions. Let's have questions. Okay. Now, okay, sir. Okay, so I am looking at one here that that I noted down while the lecture was going on. You said that a counterclaim cannot be brought against a defendant alone. Now, and I want to ask, is there any obligation on the other defendants to file a defense to counterclaim?
No. If a defendant is made an original defendant is made a defendant to counterclaim, he must file a defense to that counterclaim. Because in the counterclaim now, it will be a different number of defendants. Yeah.
How is he made a defendant to a counterclaim, knowing that the way I understand counterclaim is that we usually don't put the parties again. The parties that you have at the beginning of the process suffices. So after the statement of defense, what you just write is counterclaim, and then you go ahead to state what you want to state. So how then at what point do you say that you have been named a defense in the counterclaim to be able to file a defense for it?
Now, okay, that's a very good. I'm trying to look at my table and see if I have just a precedent on counterclaim now. The proper mode, are you with me?
Yes, sir.
The proper procedure to place parties in a counterclaim proceeding is this. Lamide, Iyabo, claimants. Are you with me?
Yes, sir.
Pedro, Tolani, defendants. Now, once a counterclaim has been filed or about to be filed, instead of putting it at the end of the statement of claim or statement of defense, you now put the parties in the front so that the court, is we lawyers, when we say we try to do hide and seek, some will file a counterclaim, they just say statement of defense. In front, they will not put counterclaim. When the defense, at the end of the defense, it is then you now see counterclaim. Are you with me?
Yes.
Now that's a wrong procedure. It's psychotic. In the front process, Lamide Iyabo claimants, Pedro Tolani defendants. Now Pedro want to counterclaim. Now under it announced it by counterclaim, Pedro counterclaimants.
Let's rearrange it, sir. Let's do Iyabo Tolani claimant, Pedro Olamide defendant.
Okay.
What to be on your side, sir?
Yeah. You're not serious. Okay, you want to be okay. So if Pedro is going to counterclaim, are you with me?
Yes.
After the first parties.
Yes, sir.
Are you with me?
Yes,
you will
sir.
now say by counterclaim, underline it, without putting the High Court of Lagos anymore. Just say by counterclaim. You now put Pedro in front, number one. That's the counterclaimant. Are you with me?
Okay, sir.
And that means versus Iyabo and Tolani, who will now be defendant to counterclaim.
Wow.
So you reverse the situation. So in the front of the process itself, anybody that carried the process is very clear to that person that there's a counterclaim in this matter. Are you with me?
Yes, sir.
So that's how it's actually done. But some people will leave the original parties in front. But when you get to the end of the defense, some people just say counterclaim and they start like that. While some people will now repeat the parties the way I have said it, putting the defendant up and putting the claimants down as defendant to counterclaim. I hope you understand.
I do, sir. But can I make a request, sir? At the time when the synopsis is being sent, is it possible for me to have a template as you have described it?
Okay. I will add it to it. I'll just look at my file and see one we have prepared. Then I'll just let you have it. Okay.
Thank you.
That will be added to it. That's good.
Thank you, sir. So questions have started coming in. Okay. Somebody is asking, can we have a sample of this? Just what I asked now. Then
yes, we will have it.
Is it possible to have more than one party's counterclaiming in a suit?
Very well. All the defendants, if they have the same relief or the same grievance, can counterclaim. So they are defendants. Are you with me? So yes, Tolani, Iyabo, who are original claimants, will now be defendants to the counterclaim filed by Ibrahim and Pedro. So you can have as many of the defendants once they have same relief against the claimant. Are you with me? Put all of them together so you can reverse the situation. All of them can be counterclaimants. So all the claimants will now be defendants to counterclaim. So it is quite possible.
Yes, sir.
The only thing you cannot do is to counterclaim against a co-defendant. That's the only thing you cannot do. But you can counterclaim against a claimant and add other defendants to it. You can even counterclaim against a claimant and bring a neutral party that is not even in the suit before. That's the one I even omitted to say. Do you understand what I'm saying?
Yes, sir.
In your counterclaim, you can, once you make the claimant a defendant to counterclaim, okay?
Yes, sir.
You can go and bring Trump in US, who was not part of the suit, to a defendant to the counterclaim. So you will have to defend that action as an independent action. I hope you get what I'm saying.
Yes, sir.
A person that was not a party to the suit at all can be brought in as a defendant to counterclaim.
Wow, that's profound. Okay, Mrs. Data will ask a question. You have the floor, ma.
Thank you. Good afternoon, Oga.
Your voice is very low, ma.
Good afternoon, sir.
Good afternoon.
Can you hear me now?
I'm trying to.
It's low.
Good afternoon. Can you hear me, sir?
It's a lot
Oh,
better.
yeah, go on. Let me see.
Good afternoon. Can you hear me now?
It's
Ask
no,
your question.
we're managing to, yes, you can go on, ma'am.
My question is this, sir. In the course of the presentation of this paper, I got a bit confused when Oga said counterclaim. I know it says is a claim within a claim, and that anyone who feels by that same suit, you have a claim. But he went further to say it's a technical defense stroke set off. Oga, please help me just explain that. Is it a set off?
Okay.
That's number one, sir. So number two is that I want to disagree with the Supreme Court. I know one day they may come back to now upon this to say that once you have found your claimant within that suit, so even if the subject matter relates to another thing entirely, you can begin to counterclaim. I think it will be a bit clumsy. That's my view. After a while, because this has nothing to do with the present subject matter. Oh, because I found the Olamide, we're supposed to be in another thing together, and there's this, and then I begin to counterclaim. So what we will have in that counterclaim will be a different subject matter altogether. Am I communicating, sir?
Yeah, you are communicating.
So I just want to get to help me just iron that middle, because by the time I have a land suit, Olamide is the one there, and then because he's the one there, and I am not counterclaiming as regards contracts. We're having two subject matters, but all within one suit. Thank you, sir.
Okay. I think all of you managed to hear the question. Anyway, I managed. You see, I'll take the last one before the first. Now, the Supreme Court decision, that's why I say even decision must be taken on the facts and circumstances of each case to become precedent. You understand? Now, it is quite possible, really, to be, I would prefer that subject matter and the issues are related for purpose of counterclaim. But it is quite possible that circumstances may come in which the subject matter may actually be different, and the counterclaim may be allowed. I'll give you an example. Now, we have known one another. Are you with me?
Yes, sir.
And we have two parcels of land, one in Ikeja, another one in Ikoyi. And in the one in Ikeja, I have sued you because when the tenants paid, you refused to pay me my share. Are you with me? I'm the one that sued. So, I say, hey, if that is so, me too, I can counterclaim against you in respect of the one in Ikoyi in which you sold and you have not given me my share. The subjects are different. And this is because the parties are same. And to avoid filing a fresh suit, under that situation, a counterclaim can be raised. They go, okay, it's money you want to collect from me in respect of the rent you collect. Are you with me?
Yes.
It's the money that you collected in Ikeja. And I say, okay, fine. A defendant there, maybe I'm the defendant or you are the defendant. You can say, okay, what about the property in Ikoyi that you sold, that you promised to pay me my share? All the facts, all these things, you are thinking maybe we'll settle that one. We have agreed to settle it in the house. Now you went to court. Then I can also come to court and say, okay, I'm counterclaiming against you. And I think in that simple format, I think counterclaim can fly. But I agree with you, if I have my way, a counterclaim must be related to the subject matter, the issues before the court, so that there won't be any confusion. Now, I have said counterclaim may even act as a set-off. Set-off is a different thing in civil proceeding. He has his own provision. But a counterclaim can be used for that purpose. Are you with me? Now, on the same subject matter, the claimants have a pending action against the defendant. And the defendant knows that, yes, I have a defense to the claim. And if my defense succeeds, I will not be liable to pay or liable to the claimant. So that's then I counterclaim that I am not liable or entitled to pay so amount. Or if at all I'm liable, I'm only liable to a limited sum of money. So in other words, it is at times referred to as you can use it as a setup against a claim by the claimant. But technically, it's an independent action, which I consider it to be a cross action to seek a relief against an original claimant. At times it is used as setup, but to me, it's better called a claim, a counterclaim. Okay?
Thank you, sir. Thank
You're welcome.
you. Yes, Mr. Shodi.
Yes, sir. Sir, can I ask a question? Yes, sir. Sir,
Yeah,
are there instances where a counterclaim, first of all, sorry, good afternoon, sir. Let me commend you for the interesting lecture. But are there instances where a counterclaim will not survive a claim? For instance, where you have, where the writ itself is not competent, or where the writ itself is defective, so that nothing will be able to stand on anything. So where in the instance that you have the initial suit or the principal suit has been either discontinued for reasons of incompetence or further to USC McFoy and others, can you still have that counterclaim saying, even though that suit doesn't survive, but my counterclaim still subsists? That's one, sir. My second question is, you did mention that you can have a counterclaim for originating, for processes that commence via originating summons. You wanted to mention, I think, explain the procedure for that. Can you also have an originating summon being counterclaimed to that originating summon? That I don't know whether I'm clear. Can you have an originating summon as a counterclaim to that initial suit that was commenced through via originating summon? So those are my two questions.
Thank you. Now let me take the last one.
All right.
Let me take the last one, the one that has to do with originating summons, because it's very technical.
Yes, sir.
Now, you know, originating summon is like a motion. That's why you have originating motion. You have originating summon. So yes, it's similar to a motion.
Yes.
There is no writ there. It is that summon itself that initiates the action. That is it. So yes, if a counterclaim is to be filed, one,
yes, sir,
I will tell you, you first of all need to file your counter affidavit against the originating summon. That is your defense. So in that, your counter affidavit, my style is to include a paragraph that the defendant also have a relief against the claimant by this originating summon, and file a counterclaim to that effect. Now, the originating summon is on its own. The counterclaim is an independent action on its own. So the way my style, because it is the authorities in that area is that a bit, okay, is to make originating summon by counterclaim. That's what differentiates it. So because you want certain questions to be answered, and you want a relief, so it's an originating summon by counterclaim. Are you with me? The claimant in the originating summon, or let's say in the Federal High Court now, instead of being a plaintiff, will be a counterclaimant in that originating summon by counterclaim. Because you know you cannot file an originating summon without asking for questions for determination. At times we make that mistake. Some people file originating summon, seek the following relief. How can you seek a relief? You must first of all have a question for determination. It is after that question for determination that you now seek a relief. But most times I have raised objection, and I think the authorities to do that. How can you file a originating summon without question for determination? Then that originating summon is incompetent. So you must have a question for determination, then the relief sought arising from that question, which the court is asked to answer. The same thing will apply to your counterclaim by way of originating summon. And when you look at the rules, like the white book I referred to, and the Ondo one, there is even, you can even seek the directives of the court, how the counterclaim should be brought. Are you following me?
Yes, sir.
So you can't.
So you can't bring it to a writ. You can't use a writ. You cannot use a writ. You cannot bring it to a writ. It has to be.
It has to be the originating summon format. Can you hear me?
Okay.
Yes, sir.
Yes, sir.
Okay, it has to be originating summon format. So I think what you should just do is pick that file on Hotelia and see the way the counterclaim was prepared in that. And that question you're even asking for, Olamide, I think you'll find in that file too.
Okay, sir.
And the way, because when I was doing my final address, I make it point blank that there are two suits and how the counterclaim was just brought in. So that anybody reading it, I think, should be aware of that there's a counterclaim. Because if you don't do that, the judge may even gloss over it and we don't know.
I guess the one you're referring to is the one before Aikawa J.
Yes.
So it was the one before 5G that I did, that we did with.
You say what?
The one before 5G.
Okay.
The one that we did. So I don't have that other one that you did before Aikawa.
I know it should be somewhere there.
We'll look for it.
You can look for it. Ask for this year.
All right.
We'll look have it. Yeah. Okay.
Okay, sir.
So the other one, you are talking about, what was the first question? This originating summon. There's the first question
about
you asked.
Competence and the
okay.
Whether something can stand or nothing.
It will stand. It will stand. It will stand whether by way of preliminary objection. You know, that's one other thing. I have one I'm doing now. I have a relief against the plaintiff in the Federal High Court now. That if this case should go on, there is need for me to counterclaim. But when I look at the claim itself, I now see that I need to file a preliminary objection to the competence of the action. So the strategy is to step down my counterclaim and just file the PO, challenge it. So if the court dismisses my PO, then I will seek to amend my statement of defense and incorporate my counterclaim. Are you following me? Because for anybody,
yes,
especially a defendant who knows that he wants to bring a counterclaim, will not ask for the main case to be dismissed in limine by way of technical way. We would rather allow the matter to go to trial. Let the court now found at the end of the day that this case has no leg. It is hereby struck out. It is hereby dismissed. By that time, your counterclaim has already entered, and the court had no choice than to give judgment in respect of the counterclaim. And there are instances in which the main claim will be dismissed, counterclaim dismissed. Both of you carry yourself away from court.
Yes.
Because you quickly filed the counterclaim. So if you had held on to that counterclaim and you had filed the preliminary, is it? I didn't get that part.
I held on to my counterclaim. I didn't file it. Now, I did not file.
Okay.
I didn't file, I only filed the PO. Are you hearing?
Okay, sir.
I filed the
Yes,
preliminary objection and wait for the outcome of the preliminary objection. If the preliminary objection succeeds, the whole case is gone. But if the preliminary objection is dismissed, I will now file my counterclaim, ask for amendment to the defense, and introduce my counterclaim. Okay?
Okay, sir.
That's the strategy.
You file a counterclaim to a counterclaim?
Yes, you can.
Let me do one, just last one.
Please go ahead.
You can.
So there's a claim, there's a counterclaim, and there's a counterclaim to that counterclaim.
Yes. It's possible.
I would think that although law thrives on logic, but this issue of counterclaim seems to me like a very wide exception. Otherwise, if a case has been struck out on maybe for lack of jurisdiction, and there is a counterclaim. So the question, like I jokingly said to one of our colleagues, that the initial suit which was instituted and a particular suit number was given to it. The moment that suit is struck out, the suit number goes with it. So what suit number would the other one be standing on?
Okay, I will answer it simply. Pleadings have been concluded,
Yes.
And the claimant refuses to come to court.
Yes.
First adjournment, second adjournment, third adjournment, while the defendant counterclaimant keeps coming. Are you saying because the case of the claimant was struck out for want of diligent prosecution, so the defendant counterclaimant should also go? No. The judge will now ask him, is your witness in court? Put him in the box. You prove your counterclaim. And that's why it's referred to as independent, separate cross-action. You understand?
Yes, sir.
Yes. So whether it's struck out, that's why I say it's rarely that a defendant who has a counterclaim will bring a preliminary objection on locus, on this. Is incongruous. Are you with me? Even if you have a counterclaim to make, tactically just wait. Do with your preliminary objection finish. And if the court refuses the preliminary objection, the court can overrule himself when he's writing his judgment to say the preliminary objection has succeeded. You understand now? So once the court ruled on the preliminary objection, dismiss it, then introduce your counterclaim. And if in the process the claimant refuses to come to give evidence, the court will strike out the case, his own case, for want of diligent prosecution, and ask the counterclaimant to come and prove his counterclaim.
Absolutely.
You understand now?
Very well, sir.
Good.
Thank you, sir. Mrs. Odusoya.
Yes, please. My Uncle P. I just wanted to thank you for a well delivered paper. We didn't expect anything less. I just wanted to find out that at times a claimant may claim against maybe two defendants, then the Lagos State government is the third. The Lagos State government may say, okay, you, the claimants, you don't have any rights on this property. One of the defendants that's already in possession also is not supposed to be on that property. Can that kind of be brought by way of counterclaim against, especially against one of the defendants that the Lagos State government wants to get out of that particular property?
Against who? Can you repeat the last statement?
Against the defendants, against a co-defendant. Against a co-defendant.
Without joining the claimants.
I said against the co-defendant. Or is it better to file a separate suit?
No, repeat again. I want to understand you. I think the network is playing.
Yes, the network. I've moved to it.
You may have to repeat the question all over again, ma'am.
Okay, what I'm saying is that at times a claimant bring an action against
Yes.
the defendant and also
Yes.
includes the Lagos state government.
Yes.
The Lagos state government comes and says that the defendants you are bringing action against do not have a right to be on that property. Can you hear me?
Hold on.
Yes, I'm hearing you. Yes.
Okay. Meanwhile, they believe also that the claimant also has no rights. In that kind of case, can a counter claim be brought?
Why not? Yes. The Lagos state government will bring a counter claim against the two of them, against the claimant and the other defendants, to state a declaration that neither of them is entitled to right of occupancy to the land in dispute. Shekina.
Okay, but what if the Lagos state government doesn't have any issue with the claimants, but has issues with the co-defendants?
Then it cannot bring a counter claim in that situation.
Okay.
That may need a separate suit on its own.
Okay. Thank you very much. Thank you very much.
Tolani said he has a divergent view.
Okay.
Tolani said he has a divergent view. So if a case is struck out, that the counter claim should also be struck out.
No.
Well, that's okay. Maybe you want to reboot. Rafiu. Okay.
Okay, I've been trying to unmute Rafiu, but it appears he is not working.
Can you see his message?
I will check it now, sir. Okay, Otumba, please go ahead while I look out for Rafiu's message.
Hello, good afternoon, sir. Good afternoon, all. My question is not directly related to the topic we are discussing, sir. But indirectly, you mentioned that originating summons should have questions for determination before it can be a proper originating summons. Now, what about if, for instance, we want to convert the summary proceedings, the unknown person proceedings, under Order 49, unknown person? You know, it is a special of originating summons. Can we convert that to writ? Ordinarily, the rules allows conversion of originating summons to writ of summons. But in this case, unknown person proceedings has no provision for question for determination.
Yes.
Can we then say unknown person proceedings can be converted to writ when there are contentious facts? That's my question, sir.
Okay, that's all right. You have answered your question too. You know, order, is it 53 or 57 now? Originating summon for possession for against quarters and all this. That's why when you see the heading, it's a special procedure. So that is different from the originating summons for interpretation, construction. You understand now? So under that one, and you look at it, even if you get judgment under that one, the court can easily set it aside. And anybody who feels interested can also be joined. Now, when there's a conflict of affidavit evidence, the court can so moto. The court doesn't have to me, at times, the court doesn't have to convert anything if it doesn't want to. The court can ask you, who deposed to this affidavit? Put them in the witness box for purpose of cross-examination. Are you with me? That's the shortest possible way. Now, you know, when you come under that procedure, once somebody is able to raise an iota of evidence to show that he's in possession, either by consent or permission of your predecessor in title, or is a tenant, any evidence to that nature, instead of the court converting, the court will say this is not a proper case for originating someone for possession for land. And that case, that action will be at that stage either to be withdrawn as being incompetent, or the court will end up dismissing it. And to avoid dismissal, as a claimant, tactically just withdraw and go and file a fresh suit for by writ of summons. You understand?
Thank you, sir. Well, the question, Tolani's view is shaking.
Yes.
Shaking tables here a lot, because there have been in the chat room, there have been views and counter views on whether, and they are saying that it is jurisdiction. Although I find this confusing, because Mrs. Ladiga here is saying that she's also interested in the view Tolani expressed, because he specifically mentioned jurisdiction. So, but I don't know, because when you're bringing an action, you don't bring an action on jurisdiction. So the jurisdiction is usually a defense filed by one of the defendants. So you cannot. So I don't know how that plays out. But Tolani is saying that, it's the same thing that I have said, that this probably constitutes an exception to logic. I guess we are being logical in our approach. The more logical we are, the more difficult it will be for us to come to terms with this counterclaim issue. Because really and truly, if something, like we have been taught in law that something cannot stand on nothing, and then expect that thing to stand. So a counterclaim is hinged on a particular action. So if that action goes away by way of jurisdiction, it means that the coming into being of that action in itself has been affected. And that's what people are saying here. They're saying that this action that your counterclaim is standing on, at the time of, you were not even supposed to have instituted it in the first place, or maybe you didn't come to the right court. For example, maybe Federal High Court doesn't have jurisdiction in a particular matter, and then but the matter was instituted at the Federal High Court. So the notice of preliminary objection was filed, and the court agreed that yes, I don't have jurisdiction. So can a counterclaim filed by one of the defendants in that action still stand? What would the jurisdiction of that matter stand on?
Now, if you have listened to my explanation,
yes,
on you see, not everything is in the law book, and law is not logic. At times, it's law. Are you with me now?
Yes,
now, that's why I say you must differentiate. If you are talking about jurisdiction generally, if the court lacks jurisdiction to entertain a suit, the whole suit and the counterclaim will go.
Very well.
And there are two different types of jurisdiction. You know, there's substantive law jurisdiction and there's procedural jurisdiction. One of the procedural jurisdiction is issue of service. Are you with me?
Yes, sir.
It's procedural, whereas there are substantive issue of jurisdiction. Maritime matter, you file it in the High Court. You now counterclaim in it. Ordinarily, the High Court lacks jurisdiction to entertain maritime matter. So all the matter goes away. You yourself, that you counterclaim, your counterclaim itself is affected by lack of jurisdiction.
Exactly.
You understand what I'm saying? So that remove jurisdiction aside. And like I just gave an example, I have one, I'm challenging the competence of an action, which I know if it goes on the merits, we should file a counterclaim. But I believe that this case is incompetent. The person that is suing lack locus. So why should I display my energy? Why don't I ask the court to strike out the whole suit? But if the court has now assumed jurisdiction, are you with me? To say, look, this matter is competent before me. He cannot overrule himself again. So I amend my statement of my defense and I introduce my counterclaim. That is when to introduce it. Are you with me? But now, let's even assume counterclaim has been filed. Are you with me? The matter will now proceed to trial. If perchance one of the defendants, like in this case I'm referring to, because I've just been briefed by an airline, and I said, what sort of case is this one? Why are you wasting your time filing defense? This matter should be under the rules on force and abattoir. This matter should go away. There shouldn't be any reason for this case. Even though the man is claiming a demand, I said, wait, let's finish this. So let's assume a new defendant now comes on board and raise the issue of jurisdiction of the court to entertain what? It's either the subject matter, and if you go to the federal high court, maybe the parties before the court. You understand? Now, if that one is affected, then the entire suit will leave.
Okay.
The entire suit will go because the court lacks jurisdiction to entertain the subject matter or to deal with the parties before it. So there's no, even the counterclaim, you know, just like you can raise. And I can tell you, the one just recently my lawyer just went to do has to do with AMCON. Are you with me now?
Yes,
and they filed a GTB, file a counterclaim. And I raised an objection to the counterclaim, jurisdictional question to the. So you understand what I'm saying now? I also raised jurisdictional question against the counterclaim filed by GTB. I said, what are you counterclaiming? You said the liability in question, you have sold it to AMCON. AMCON is a party to the suit. You are now counterclaiming that my client should pay the money again. The same money AMCON is asking me to pay, which I'm challenging AMCON. I think you understand what I'm saying.
Yes.
And the jurisdiction will say, hey, you have already Nemo that. I mean, is it Nemo? Yeah, it's Nemo that. You have already sold or you have transferred your interest to AMCON. Why are you now counterclaiming? In fact, you ought not to be in this suit anymore. So why are you counterclaiming? So in that situation, you can see that a counterclaim itself can be affected by lack of jurisdiction, not to talk of the main suit itself. So if the main suit is affected by jurisdiction, not procedural jurisdiction that can be waived. You know, there are some jurisdictional issues that can be waived.
Yes.
I've not been served, and now I appear in person, and I participated in the trial. You are now saying there was no proof of service on me after you have participated in the trial. Whereas if you have not been served, you understand, it goes to jurisdiction of the court, but it's procedural. You can waive it. So that is the type of the one I'm referring to. For case to be struck out, you didn't come to court. When you have filed your process, the matter was struck out. So why should that affect my counterclaim? But if it is a substantial issue of law jurisdiction, whatever affects the main claim will surely affect the counterclaim. I think it's clearer that way.
Thank you very much, sir. I'm happy about this clarification.
Okay.
I'm happy about this. So Bumi is asking,
right.
yes, Bumi is asking, can a counterclaim be filed where counsel does not have a strong defense? Or how do I know when to file a counterclaim?
No. Where you don't have you may not have a strong defense, but you may have a relief against the claimants.
Okay. Even
though you don't have a strong defense. For example, okay, fine. You have sold your land. You have now refused to give the land to the purchaser. The purchaser has now sued, saying, I'm entitled to the land you sold to me. You have sold the land, you have signed a deed of assignment. Do you have a defense? You don't have a defense, but you can counterclaim. That say, yes, so when I sold the land to you, in fact, the agreement that you are supposed to pay me 10 million. When I signed the deed, you only paid 5. So I'm counterclaiming for the balance of 5. So you don't have a defense, but you may have a counterclaim.
That's very profound, sir. I mean, if I were to select questions that I would ask, I certainly would not ask that. But from the perspective in which you have looked at it now, so it is clear that yes, even though I may not have a good defense, but yeah, so the fact that the court will rule against me for not having a good defense is totally different from what I have.
That is why that's why I told you separate judgments. You understand now? They must have its own separate judgment. The court must rule on it. It will have its own separate costs. So I may lose as a defendant. You may get judgment against me. I may succeed in my counterclaim, depending on what I'm, like the simple example I've done. I cannot deny that you are entitled to specific performance because I have collected part of the money, I have signed deed of assignment, I have put you in possession. Now I'm now disturbing you. You now went to court, you sue me, and I said, fine, I don't have a defense, but I have a counterclaim against you because there are certain amount of money you ought to have paid me, or not all the parts of land that was sold to you. So I have a counterclaim on the balance. So how many minutes more for me?
Well, we are enjoying this so much, sir. We forgot we forgotten that you earn per minute.
Well,
well, please bear with us, sir. Now, well, this is the next question. I mean, a direct way to ask it will be, okay, can a busybody file a counterclaim? But Mrs. Fashayede has brought it in this manner. She says, will it be correct to say that the third party who are to be joined, the parties who are to be joined as defendants to the counterclaim must be first joined to the suit through an application for joinder?
No. If you are introducing a party by way of counterclaim, you don't need an application to join that person because it's only a party. Are you with me? To the counterclaim. It's not a party to the main suit.
Okay, no,
so you can be a party only to the counterclaim without necessarily being a party to the main suit.
Okay, sir. Thank you, sir. Okay, so okay. Well, another one here says, where defendants have separate counsel, can the counterclaim be brought individually, or does it have to be jointly done?
You can, since you have separate counsel.
Yes, sir.
And you may definitely have even same or similar relief. It can be brought separately.
Okay, sir.
Separately, and I think which one am I doing now? Separately, yes. Can be done separately.
Okay, so we've already answered this. If the main claim is affected by jurisdiction and the counterclaim is not, can the court proceed with the counterclaim? I think that has already been answered.
That has been answered.
Okay, so, well, I guess, can you file a counterclaim when claimant is not a party? Sorry, can you file a counterclaim when the claimant is not a party? Can you?
So the counterclaim.
Yes. So this is
that has been answered.
It has not been answered. So a defendant cannot file against another defendant.
That is it.
Yes.
Without joining the claimants.
Wow. I guess all the questions have now been answered, but we're going to ask you to come back again, sir. We're going to ask you to come back again because maybe not to discuss counterclaims, but to look at another subject.
Subject. That's all right.
This has been very interesting and insightful.
Always ready to
educate.
To do that. Okay.
Yes. Thank you.
That's all right.
All right. So.
Okay.
Thank you very much. We're indeed very grateful, sir. Thank you all for coming. All right.
You're most welcome.
All right, sir.
So thank all of you for listening, and I hope you have benefited one or two out of it.
Immensely, sir. Mr. Ojo is clapping.
That's all right.
I see Mr. Ojo clapping. I'm sure that if we were in a physical location now, the round of applause would have been very loud. Thank you very much.
Okay, well, thank you very much.
Thank you, sir.
Nice at least seeing your faces again and talking to you. Otumba, how are you?
Again.
Eh?
Otumba is asking me to unmute him.
Yes,
sir, I just want to ask this question on jurisdiction.
Sir,
I'm sorry, sir. Assuming the court does not have jurisdiction with regards to the main claim. But what about if the court has jurisdiction on the counterclaim, if they are not related issues? Can the court still go ahead with the counterclaim, despite the fact that it has no jurisdiction on the main claim?
Well, that's exactly the point I was making the other time. That for me, I would rather prefer the counterclaim to be related to the main claim. But in a situation where they are unrelated and the cause of action there is within the jurisdiction of the courts, being an independent action, that's why I say you must know the type of jurisdiction you are talking about. Are you with me? If it's a substantive law jurisdiction, it will surely affect the suit, both the claim and the counterclaim. But if it's a subject matter jurisdiction, are you with me? Then because the counterclaim is an independent, separate, a cross action on its own, that is entitled to his own pleadings, entitled to his own judgment, entitled to his own cost, and the court found, because the point is when it's being raised, one should draw the court's attention to it so that the court can pronounce on it too, once and for all, so that nobody is mistaken. You understand what I'm saying? When I started, I said I have a matter. I was doing, they're asking that the claim of the claimants who they have issues with the state. And I said, I'm not opposing. You don't concern me. I'm not the claimant. I'm a counter-claimant. You cannot say because you are staying the place of the claimant, mine should stay. And of course, we went on and went on. Depend on the type of judge, if you understand. So we are still on it. I said, I can fight it though, that you can't stay proceedings. But if you want to stay proceeding, the alternative, you can stay the claimant proceeding. Not my own. You understand now? Uh-huh. And I think one of the matter, where is, what's his name again? I have another matter related to chieftaincy matter in which the ministry is also involved. And there was an appeal to the Court of Appeal. And they want stay of proceedings. And I told the judge, I said, look, as far as I'm concerned, stay of proceedings, I am the claimant. Allow me to finish with my witness in the box, who is over 80 years old. After this witness, let the lawyer for the defense cross-examine. After that, court, you can stay proceedings because of the effect it will have. Before the Court of Appeal determine the interlocutory appeal now, it may be another 2-3 years. The 80-year-old man who is in the box will have passed away, and that defeats the case of the claimant. And the trial judge agreed with me. And I was trying to push further. I said, this stay of proceedings thing, how can a defendant ask for stay of proceedings in a case because he have an interlocutory appeal relating to whether the case is statute, bar, or jurisdiction? And my position, which I've canvassed also in the Court of Appeal, they say we should come back, is simple. I said, look, we must begin to change these our rules to avoid inconvenience. And my position in the Court of Appeal, I said, my lord, tell the defendant to go back to the High Court. Let me, as claimant, complete my evidence, call all my witnesses, let him cross-examine. When it is the time for him to open his own defense, we can stay proceedings. You know, the advantage there is this. There are many cases we have done. In another 5-10 years, all the witnesses are gone. So, but the Court of Appeal is yet to determine. But that's, I think, is a way we can be proactive. I'm not saying don't stay proceedings. Supposing the Court of Appeal dismiss the interlocutory appeal, won't it come back? So if you appeal to Supreme Court again, and the main suit will be there. So if it is the defendant that is asking for stay of proceeding, no problem. But let the claimant conclude his evidence. And that is what we have introduced in criminal procedure. That you can't raise anything until after the close of prosecution case. Then begin to raise whatever you want to raise. So you will know it is left for the defendant. The prosecutor will have closed his case. He has called all his witnesses. Olapa can travel to Sokoto, so nobody be looking for IPO anymore. It is for the defense that has wahala now. You can pursue your interlocutory appeal. Still, maybe you ask for no case submission. It is overruled. Go to the Supreme Court. So when you come back after 10 years, it's you that you have to come and give evidence. So that is you understand now? So to be proactive about it. So those are part of the things that when you come to jurisdiction, which one? If this one doesn't have jurisdiction, let it go. But the court should be reminded I have a counterclaim, and I don't believe the counterclaim is affected with the let the court rule. And when the court rule, you can even appeal against it also. And that's how we develop the law. Okay? Good.
Thank you very much. So
okay.
We will officially be ending now. Mrs.
Okay, thank you very much.
Mrs. Alowole says, thank you so much for the interesting presentation, sir. Rukia Adamosi says, thank you, sir, for the well-presented presentation. I have benefited immensely. And I'm sure a lot of people also want to do that.